All right, so let's switch gears a little bit. Let's talk about copyright and trademark. That's another thing that I've had so many people ask me about or just ask in the community online that I run. And I feel like there's a lot of misconceptions about copyright and trademarks, and they get people get those things confused, and they think one is the other and whatever. So first of all, what exactly is a trademark versus a copyright? And then what are some of the main things that people they just need to be aware of?
Copyright is the exclusive right to essentially to make copies of your original creative works. So to make copies, to distribute, to publicly perform, to create derivative works from. So if you make one game, to be able to make any kind of sequel or derivatives of that work, that's your exclusive right as the copyright owner, and that others are not allowed to do that with your work. And it has to be an original creative work. It can't be anything that's functional or factual within the work. It can't be anything that's sort of like an underlying game mechanic. It needs to be like an actual creative thing, like the text of your rules, or the graphic design and the artwork of the game, or things like that, things that are creative in nature and not necessarily. Now, obviously, game designers would probably say that there's a lot of creativity in the game design itself, but unfortunately, the law doesn't see it that way. And you can visit my blog. I have blog posts about this, some of the cases about this, what is sort of protected by copyright in a game. And unfortunately, the design and the mechanics and, characters' powers and things like that are not going to be protected by copyright. So next is trademark, and trademark protects something totally different. Trademark actually protects consumers from being confused about the source of the goods that they buy. So imagine you walk into a store and you see a bottle that says Coca-Cola on the label, right? But it's made by some guy down the street in his bathtub, but he's just slapping the label of Coca-Cola on it. You don't know where you don't know if there wasn't trademark law, and if they weren't allowed to stop other people from doing that and give those exclusive rights to a trademark owner, you wouldn't know where your products are coming from. So that's what they try to accomplish with trademark law. And it's going to protect your brand names, like your game name or your company name, and then your logos, your maybe the trade dress. One famous one is the shape of a Coke bottle is very distinctive, and they can protect that because that gains so much distinctiveness with consumers that the law wants to protect that. So again, you can't walk into a store and see the same exact bottle shape and think that it's made by Coke. And then there's patents. Patents protect innovations and inventions and improvements to other inventions, things that are not obvious to other practitioners in the field. And those are maybe less common in board games and video games, but they're still there. I mean, there's still lots of them for sure. I don't know. And then there's something called trade secrets, which is the fourth type of intellectual property. And that's basically any kind of secret that you have that has some value in the industry that you're in. A big one, again, going back to Coke, would be the formula for Coke, the recipe for Coke, right? That's something that a recipe, because it's just functional, it's a list of items, is not copyrightable, but it is something that you would have to keep secret. And, the catch-22 of protecting intellectual property is that you have to register it in order to protect it. So if you have something secret, you can't register it. So you basically have to just keep it inside, only share it with people that are under NDAs and all of that. And that's maybe one of the reasons why everyone wants NDAs, especially from the big companies, because these are not copyrightable things. Maybe they're ideas or plans or something like that, but they want to keep them secret.
Gotcha. First of all, knockoff Coke made in a bathtub, I think, is the origin story of Pepsi.
I have no doubt. At least Dr. Pepper. Yeah.
All right, so let's talk about copyrights just for a second. How do I have to file a copyright, or as soon as I put it out into the world, is it automatically legally binding copyrighted? Like, how does that work from a legal standpoint?
From a legal standpoint, as soon as they call it fixation. As soon as you fix something in a tangible medium of expression, you have copyright rights. That means when you write something down, when you save a digital file on your computer, when you record a video or take a photo of something copyrightable, you have rights, underlying copyrights in that thing. The issue is, at least in the US, you can't actually do anything with those rights. You can't file a lawsuit against someone unless you've registered that copyright. So, and it used to be that you just had to have filed for the registration, because when you file it, it can take 3 months, it can take a year to get the actual registration, depending on how quickly the Copyright Office is moving. Supreme Court a few years ago ruled that it needs to actually have been registered before you can sue someone. So what's happened sometimes is I will have a client and we want to send a demand letter to someone that says, hey, you're infringing on my copyright. You need to stop. And they'll come back and say, well, where's your registration? Because they basically know that we can't do anything without that registration. Now, fortunately, they do offer you an option, graciously allowing you to pay $800 extra to get an expedited copyright registration, which actually takes about a day, which is great, but it's additional cost that you don't want to have to pay if you had just filed it the day that you created the thing, right? You publish your board game and you file a copyright registration that day, which is probably the best time to do it. And then as far as trademark goes, at least in the US, when you use a trademark in commerce, which is to say you actually sell a game with the name that you want to trademark, you have trademark rights, and you have something called common law trademark rights, which is, unregistered, but you do have the ability to protect that. It's not as good as the registered trademark, which allows you to sue someone for trademark infringement in federal court. But really, what I find to be the most useful benefit of a trademark registration isn't the protection you get later on, but it's the protection you can get from the beginning. So with games specifically, most of the time a developer or designer will come up with a game name, let's say today, but they're not actually going to get that game into consumers' hands for another couple years, right? So in the time between today when you've decided on the name and the time when your common law trademark rights accrue, that's a couple years that other people could have been coming up with the same name and actually releasing products. So you're not going to have those exclusive rights, and that other party is going to have the rights to that name. So you may have wasted months or years advertising a game under a certain name, and then you have to change it at the end, right? Because you haven't filed any kind of trademark registration. Now, if you filed a trademark application today, you could file it as what's called an intent to use application that then gives you rights dated as of the day you file it, even though you don't actually use it until later on, which is, I think, the most important part of trademark registration, the reason to do it for especially board game and video game developers, because you don't want to waste that time marketing your game when you don't even really have the rights in that name. Does that make sense? Sometimes it can get confusing, the intent to use and all the dates and all the craziness. But trust me when I say it has happened more than a few times with clients of mine where we're lucky that we have filed that trademark application. And sometimes it can be we send a demand letter and say, hey, we filed this application. You can't use this name. Maybe they run a Kickstarter and then we can contact Kickstarter potentially. I mean, the technicality of it is that even though you do have those rights going back to that day, until you've actually finally and fully registered your trademark, you don't actually have those rights. So you kind of need to register it first and then come back and say anyone that used it in that period of time is infringing. But we can certainly send a letter to warn them and say, hey, this is going to happen if you don't stop using this. And a lot of times they will stop. Nobody wants a letter from a lawyer. Unfortunately, I'm a nice guy, but nobody wants to hear from me, unfortunately, which is good for you if you're the client, but bad for me and maybe personal relationships or whatever. But yeah, it's definitely useful, and it has happened. I can tell you from real world experience, we've had to do that and had to stop other people. And sometimes you can even sell the trademark to someone else, right? If they, you've spent $1,000 getting this trademark, but maybe a big brand comes in and starts using it, you may be able to sell that for a lot more. Maybe it's 50,000, right, that you sell it for, which is, a good deal if you're a small game designer.
Yeah, that makes a lot of sense. I've also seen, going back to the whole idea of preemptive thinking ahead, like really thinking about what you're going to do long term. I can't remember what company it was. This is a video game company a few years ago. They were so excited about this game they were working on, and they put out a trailer, but they hadn't gotten the domain, the URL for the website. Yeah. And so some random dude on the internet saw the trailer, was like, oh, okay. And he went on GoDaddy or wherever and was like, oh, this URL is for sale. And he registered it and then sold it to the company later. And so,
that does happen. In fact, it's something I'm sort of dealing with right now. It does happen a lot. And there are companies that are out there that are just watching new trademark registrations and seeing if they can get the domain names. There are procedures in place to help deal with that. If someone registers a domain in bad faith, then you could potentially do what's called a UDRP proceeding to get ICANN, which is the domain name authority. You can get them to basically give you the domain name back if it's been done in bad faith, and you can prove that you have a registration. It's a little tougher, though, if you only have an application and you haven't actually started using it before that person registered the domain. So yes, the lesson is get your domain names registered along with your trademark registration once you decide on your name, for sure.
Now, I've seen a lot of board game publishers. I think it's a little different video games because the ceiling for the amount of money you can make is so much different in the video game space. Board game space, margins are kind of low. It's hard to make a lot of money. You're probably only selling a couple thousand copies, if you're an indie publisher. So with that being the case, is it always worth it to go through all these processes and spend all the money that it goes into to file the trademarks on? Or are you really just putting yourself more in the hole, especially if you're just, registering a game title or something like that?
I'm nodding my head, but the answer is no. It's not always worth it. And a lot of times what people will do is wait until they see that something is a hit, put it up on Kickstarter. If it starts to get some attention, then you file the trademark for it. And, the things I talked about are risks, other people using your name or what have you. They're risks, but they're probably low risks. So if you're okay with sort of accepting that business risk and maybe you have some flexibility, you can change the name or sort of deal with whatever problems come up, then I totally understand not wanting to pay $1,000 to register a trademark. And I will tell any client this, I'm not like, you must do this. I mean, I think it's a good thing to do, and I think it's very helpful for the reasons I talked about, but I totally understand that it is not cost effective until it becomes a problem, right? And then you will have wished that you did it. But if you're okay and you're flexible enough that you're okay changing the name, there have been things where someone's put a game up on Kickstarter and then they've gotten a trademark takedown and they've had to take down the whole campaign, and it kind of messes with the campaign. Had they done a clearance search and maybe filed a trademark application beforehand, they could have avoided that. They could have come back to Kickstarter and said, hey, actually, I have a registration for this or what have you. It's all risk. It's all risk assessment and, seeing what you can accept. And that's fine. That's a lot of business, right? It's just the name of the game.
Am I remembering correctly that a trademark only works for the country that you file it in? So if I file a trademark in the US, then, a company in Canada, they don't care. They can do whatever they want. Is that right?
Correct. Yeah. They're territorial. And again, you want to talk about costs. Yes, you can file in the US and then you can take that US application and file it in the EU and Australia and Japan and, all over the world. But the costs get kind of astronomical. If you wanted to do every country in the world, you're going to pay tens of thousands of dollars, right? So most likely it's not worth it. So what you want to do is figure out your biggest markets potentially, and then maybe file in those. But again, it's a cost benefit analysis. I mean, the problem is outside of the US, it's generally a first to file jurisdiction. So what we'll have a lot of times is a game gets popular in the US, and then in China or in the EU, someone else is going to file an application for that because they're getting in before you, and they then take those rights, and maybe they want to extract money from you, or they want to, do their own product with that's a knockoff of yours or something like that. But that can be a real problem. So again, I mean, I hate to say it, but I mean, it costs money to protect all this stuff. And, you're going to pay $600 US to just get into that international system. And then each country then has their own fees after that. So, I mean, it gets real pricey. You're going to pay thousands of dollars to get in the EU and in Canada and in the US and everywhere. But, if it becomes a problem, you're going to wish you had done it. It's the unfortunate sort of reality about this stuff. Protecting yourself legally costs money, unfortunately.
Right. Are you telling me that there are companies in China that make knockoffs of things?
Yeah. Or sometimes they don't even make them. They just register a trademark, which is crazy. And then, you can get the trademark back a lot of times because, you can prove that they show that we can show that they registered dozens of trademarks and never actually released any products or something like that. But it costs thousands of dollars to fight it. You need to go back and forth, and it takes years to do it. And it's just a huge pain. So, if you can get it in there beforehand, that would be way, way better. But again, it's going to cost you another $600 or so to file a trademark in China, unfortunately. That's what do you have to sell? Another 1,000 games or 500 or 100 games to make up that money, unfortunately.